My name is Stephen Wood. I'm the director of the Center for Law and the Environment at the Allard School of Law, University of British Columbia.
Mention that.
Coming to you from the traditional, ancestral, and unceded territory of the Musqueam Nation and very close by the Squamish and Tsleil-Waututh nations, who have been stewards of the lands and waters of this place for millennia. And that is something that we should keep in mind as we enter the discussion we're going to have today. So we're joined today by speaker, Aimée Craft. I'll introduce her briefly and then let you know how we're going to proceed. For those of you who don't already know, Aimée Craft is a leading figure in the resurgence of Indigenous laws and treaties relating to water. She's an associate professor at the Faculty of Law in the University of Ottawa, where she holds the University Research Chair in Nibi-Minawa-Aki Inakuniguin, Indigenous Law and Governance in relation to land and water. Aimée is Anishinaabe Métis lawyer from Treaty 1 territory in Manitoba. She co-leads a series of major research projects on decolonizing water governance. She also works with many Indigenous nations and communities on Indigenous relationships with and responsibilities to Nibi water, and plays an active role in international collaboration relating to transformative memory in colonial contexts. I'll refer you to our website, the event posting, for more details of Aimée's illustrious biography. Today, Professor Craft will be sharing with us some stories and knowledge from her work on decolonizing water governance. And the title of today's talk is a bit of a mouthful, but I'll try and go for it. Indigenous Legal Principles and Values as an Opportunity for Coordinated Multi-Jurisdictional and Transnational Freshwater Governance. Her remarks will be followed by an audience Q&A. We have people in the room and online. So let me just let you know that if you're in the room and you'd like to ask a question, we'll ask you at the appropriate time to come a bit forward. We have a line of microphones on the second row of desks, and you will really only be heard if you are either in that row or the row immediately behind. So that's how we'll do it in the room. Online, for those of us joining online, please use the Q&A function in the Zoom controls. So you can put questions in the Q&A at any time. You don't have to wait until Professor Craft has finished her remarks. And we will moderate the online Q&A in an integrated way with the in-the-room Q&A when the time comes. But don't try to use the chat format. We're not monitoring the chat. We are monitoring the Q&A. I think that's everything in the way of preliminaries. Thank you again very much for joining us. And please join me in welcoming Professor Aimée Craft.
Thank you so much. I really appreciate the invitation to be here today. I'm sorry for the long title to the presentation. It's actually decolonial water governance. That's what we're going to be chatting about today. And I am currently on sabbatical, so please bear with me and be patient. The person I talk to the most right now about these ideas is myself, usually in pajamas in my living room. And I'm grateful for the opportunity to kind of test out some of these ideas with you today. And I'm really looking forward to the discussion that we'll have following some of the things that I'd like to share. When I was invited to speak, I questioned myself a little bit in terms of what I bring to the table. I'm from a treaty context. A lot of my work has been on treaties. I'm just going to ask for tech support because I can hear myself.
Just a little echo, if we can figure that out.
It's very much like being in my living room in pajamas. So I'm not from a BC context, and a lot of the examples that I look to are actually emanating from this jurisdiction. I like to think that what we're doing in the Prairie Provinces, which is where most of my work is cutting edge for those spaces, but I know that there's often this divide between tidal nations, kind of British Columbia political legal context, and the space that I'm working from. So I thought I would anchor most of my remarks in a context that might be unfamiliar to you today, which is the Lake Winnipeg Watershed. And so the three empirical study pieces that I'll share are emanating from there. In some ways, what I wanted to share is kind of my state of the union. As I said, I'm on sabbatical, having a midlife crisis, call it what you will. I'm trying to figure out how the alignment of the different pieces of my work are fitting together. And in large part, that's driven by a project on decolonial water practices. So working with Indigenous nations on decolonizing our water relationships. But all of it is basically leading to my desire to unpack this question about how the revitalization and recognition of Indigenous laws and legal orders, values and principles can impact water governance and inform environmental governance that takes seriously those Indigenous laws and legal orders. A lot of this thinking is also attached to broader environmental governance, so not just relating to water. And I brought two physical copies of shared reports here that are work that I've done with the David Suzuki Foundation on shared governance and governance back.
Pass them around.
Sure, yeah. Do you have an answer on this?
She's getting the IT file.
Thank you. All right, so the two David Suzuki Foundation reports were an opportunity to think through and actually probe this nexus between governance and management. And it will not be a surprise to many of you that in large part, Indigenous water governance has been relegated to management, sort of the peripheral activities of addressing a particular issue, problem relating to water, and the more circumscribed or minute ways of managing those problems or issues through sets of values and principles, often using Western science as lead, and in some cases incorporating Indigenous knowledge alongside that Western science. What I want to probe is how, by flipping from management to governance, we can actually step into spaces where Indigenous laws and legal orders are framing the process of how decisions are made, and also the attached values and principles relating to those laws and legal orders in ways that meaningfully affect governance and decision making. So I'm hoping this makes sense to you, that departure from management to governance, which really hasn't taken effect on the ground when we think about Indigenous people within environmental governance spaces. The key pieces to that are that procedural involvement and engagement in accordance with those Indigenous values, and then the values and principles that attach to that. And I want to think of them as two different pieces that are correlated. So in order to do that, I think we should talk about the trajectory maybe of this work from land back and a series of videos done with the David Suzuki Foundation on the concept of land back and what that might mean. The Yellowhead Institute report on land back tells us that the project of land back is about reclaiming Indigenous jurisdiction, breathing life into rights and responsibilities. And then to speak a little bit about the confluence of land back with the idea of governance back and moving from governance back to shared governance. Thank you so much. Oh, I can still hear myself. Moving from there to shared governance or shared decision-making. So how we step into spaces of collaborative governance in ways that recognize Indigenous laws and legal orders. And then looking at some specific decolonial governance initiatives in that Lake Winnipeg watershed that I mentioned in the 3 case studies that I'd like to share with you today. And then some musings around the future of freshwater governance in Canada, what that might look like. And that can lead us into our discussion. Do we have agreement?
Yes.
Shall we move forward? Good. Important to remember process, right? And I'm saying that because in a lot of these spaces that we've looked at in the context of developing these reports, process has been very much westernized, work as an administrative tribunal or board, led very much by non-Indigenous process until a shift maybe 15 years ago, a shift that's still in process. And you'll see that the conclusions in the report lead us to findings that when Indigenous process is used, when Indigenous languages are present, when on-land activities are taking place, when ceremony is part of these processes of decision-making, the Indigenous knowledge and the values and principles are significantly heightened as part of that process. So process does matter. Okay, so we're starting from a few premises. Land back can mean different things to different people. Basically, it's Indigenous people being in relationship, whether or not that's a new relationship, restored relationship, historic relationship that's remanifesting itself, relationships to land and water. The significance of that is as sources of livelihood, culture, spirituality, reciprocity, ceremony, and sustenance. We know that the colonial project has attempted to interrupt this for a variety of reasons that are beyond this talk. But that in that colonial project, there's a desire to take land and water for extraction and development purposes and to exclude Indigenous people from that decision-making. 90% of land in Canada is governed as Crown land. And so that leaves us with this very important question about what's the involvement of Indigenous people in what the Crown perceives to be its Crown land. I won't get into land theft, doctrines of discovery, terra nullius, these shaky foundations of the Canadian legal system on which this is relying. But let's talk about land back and the importance of it. I do want to pose the question specifically, though, about conflicts of laws. And I want you to sit with these images here for just a moment. Can anyone identify where these images are from? Do they look familiar to you? I think I heard it. No. Standing Rock. Okay, so Dakota Access Pipeline conflict. In particular, in the bottom right-hand corner, I'm not sure if it's the same for those of you who are online, but where we have 2 lines of legal authority being asserted, we have settler law, state authority being exercised in the face of a legitimate Indigenous legal order that's raising its obligations of water protection and responsibility to water. So whereas the state says civil disobedience, trespassing, Indigenous water protectors are giving effect to a different system of law. And I expect that this conflict of laws is going to resonate with many of you. It is definitely going to play into a collective water governance future. The question is, how do we deal with those spaces of conflicts of laws? And as I've already shared with you, both process and substance are going to be incredibly important in doing that. Do we have an answer on this?
Oh, I have one more idea though, but.
Wonder if I might. Yes, okay, can you hear me? Everyone in the room can hear me? I'm hoping online you can hear me. Online won't be able to see me.
I can see if we can move,
Yes.
to move the camera. That should work fine. You can come in over here.
Yeah.
Good. All right. So land back, as I said, is about honoring and restoring Indigenous relationships to lands and waters. And in the report that we produced with the David Suzuki Foundation on governance back, we looked at a few case studies that allowed us to draw some conclusions. One was that governance back didn't look the same in all contexts. So we had Indigenous municipal alliances, self-government agreements, land trusts, governance reclamations by legislative grant, conservation and cultural easements, declarations, Indigenous protected and conserved areas, and nation-to-nation partnerships to restore compromised environments. So every single one of the examples that we looked at had a different nature of quality to how governance was reclaimed. In a lot of cases, it had to do with return of territory in some way, or return of control or jurisdiction or management over that territory, but was affected through these different types of relationships, including strategic partnerships, contracts, funding mechanisms like trusts, agreements to steward and safeguard previously dispossessed lands and waters. So a whole range of different approaches. And these are the case studies that we undertook. There have been some updates since this, and I'm happy to report that in January, the Seal River Watershed Alliance actually signed an MOU with the Government of Manitoba and Canada to withdraw the entirety of the Seal River Watershed from any mineral dispositions and mining. So it's now in a pre-protected phase, and they're doing a feasibility study for an Indigenous protected area. They have a wonderful film that was released last week, We Are Made from the Land, that illustrates the special relationship. So a lot of initiatives are taking to kind of public dissemination about their interest in the protection of those interests. And a lot of this work is being done through Indigenous protected and conserved funding, as well as guardian programs in Canada. Work of that similar type. One of the features of the case studies that we did was that in a lot of all of them, there was collaboration either with state or private entities to realize the goals. In some cases, there was full decisional autonomy and repatriation of lands. In other cases, something more of the nature of administrative agreements. And progress has been made to governance back, as we illustrated with the case studies, but definitely something felt like it was lacking in terms of the full return of jurisdictional authorities in lands and territories. Again, very much towards this management of lands and territories, symbolic restoration of relationships, access to land and territory, but always in this constrained manner where the government decision makers were always either funding and exercising power through funding or remaining the final decision-making authority. So setting limits and bounds on the ability to effectively manage and govern territory. So reclamation of land without the ability to meaningfully participate in decision-making, that is to have the land that's subject to the authority of other government, falls short of achieving self-determination and true territorial sovereignty. In many ways, Indigenous management of resources is perpetuated through these mechanisms, and the ultimate decision-making and governance remains with the Crown. So in the shared governance report, which followed governance back, we undertook to consider initiatives where there was more direct engagement in the governance and decision-making of related to water and land. Okay, so what we looked at in the shared governance report were structures of co-management that were created with varying degrees of success. Some are longer dating, some are still being developed, that are mostly in the North and in British Columbia. So highly utilized areas, highly industrialized areas are generally not subject to this co-governance approach, and that's still kind of a following trend, right? So where decisions are made tends to be territory that is more remote, some potential industry, but not highly industrialized and less populated, so very little title, fee simple title or private property interests within those co-managed areas. They also tended to be very much focused on either a particular area as being managed or governed, or a particular resource. And in some case, there's reason for that. I think of the Beverly-Kamenieriak Resource Management Board. This is a very complex board. Part of the critique has been, well, it's a recommendatory board, so their decisions are not binding. But at the same time, this board is dealing with multi-jurisdictional arrangements and being the guiding and unifying source and authority on how caribou populations are being treated. Also thinking about how they have a voice in regulatory proceedings relating to other natural resources and how they've been able to influence those decisions. So although they're subject to this critique of being recommendatory, they actually have a fair bit of persuasive power. Other co-management boards do not have the same fate and have been recommending but being overturned by settler governments on a regular basis. We have kind of the new model, the new approach that's being taken where there's a recognition of mutual authority, whether there's an agreement about that authority or an agreement to disagree about that authority. That's kind of the new model, kind of the jurisdictional landscaping of this is what we're going to try and collectively achieve together, although we may not agree on spaces of authority. So different types of models historically and contemporarily. As I said, sometimes it's managing the components of a landscape, sometimes it's managing a particular waterscape. And how Indigenous knowledge is treated within each of those co-management or co-decision-making initiatives is hit and miss. It really depends on how the structures are agreed upon. So the critiques, obviously, final decision-making authority is very rarely resting with Indigenous nations, but where Indigenous voices are prioritized, so that includes actually the use of Indigenous knowledges and Indigenous languages within those decision-making authorities or entities, then we're seeing actual legitimate engagement with parts of Indigenous laws and legal orders within the decision-making. The success has also been very much related to on-the-land presence, often through guardians programs. So we see that there's a direct correlation between guardianship on the land, use of Indigenous language, and not surprising to anyone in this room, actually having Indigenous people at the table. So not just as representatives of Indigenous governments, but as representatives of settler governments as well, who are appointing Indigenous participants. I'm told that Taidene Nene board is operating in their structure entirely or almost exclusively in the Dene language, which for those of you who are English second language speakers or who have experience in another language context, you'll know how much language influences relationships, how decisions are made, and sometimes the ultimate outcome of those decisions. And as I said, where there are cases where jurisdictional questions are put squarely into the planning and foundations of the governance structure, in those cases, there was an enhanced ability to develop consensus amongst issues of concern. All right, so it remains, though, that the ultimate jurisdiction over lands and resources often remains with the Crown, and that's in stark contrast with the inherent authority of Indigenous peoples within their own territories. It's also in conflict with UN DRIP, values of free, prior, and informed consent. Interviewees, as part of this project, told us and agreed that true shared decision-making should be adaptive, flexible, Indigenous-led, and properly resourced, and that it needed to consider economic, social, environmental well-being and rely on Indigenous systems and principles of governance that have been applied for millennia within these territories. So none of this is really surprising, but it was bringing all of these voices together to kind of look at what are some of the major challenges in trying to co-manage or co-govern, and what are the gaps that demonstrate themselves in each of these initiatives, and questioning whether or not they are able to realize Indigenous governance. So the picture was a little bit grim, but there were some hopeful moments, and you'll see in the reports that we indicated some of the successes. One of the key factors was self-funding, and that changed the dynamic as a starting point in shifting the relationship and power imbalances that existed. So that's part of the Decolonial Governance Project and the work of Decolonizing Water Governance, which was actually started here at UBC. Gordon Christie was one of the original co-applicants on that grant. The PIs were Karen Bacher, and there were a variety of people involved from this campus across Canada. And the grant has evolved in its work and has shifted from the north to mostly Anishinaabe territory. Deborah McGregor and I co-lead that grant that's about to finish now. So yes, I get to do the paperwork and reporting on everything that we've done, but a lot of students trained through that initiative as well. An important work being done in community. So a lot of the more recent work of Decolonizing Water has been within the Lake Winnipeg Watershed, and I want to speak to 3 of those initiatives now before we get into our discussion. Just as a reminder, it might not be a reminder. Those of you who are unfamiliar with the waterscape of the Lake Winnipeg Watershed, this is a map of the territory. So you can see it's starting in the Rocky Mountains in the west, down into the United States, all the way up to the Hudson's Bay is where this water flows. This is the second largest watershed in Canada. It's about 1 million square kilometers. It spans 4 provinces, so we have a significant geographical consideration here, but a jurisdictional one that's important as well, with a transboundary for American states being involved also. Lake Winnipeg itself is the 10th largest freshwater lake in the world. So if some of you are asking, why do we care? It's actually an important water resource in Canada and the world. It's the 3rd largest hydroelectric reservoir in the world. So it's highly impacted by regulation of water levels by the Crown Corporation in Manitoba. And there are 12 rivers that flow into this water, as I said, that ultimately leads to the Hudson's Bay. So the first of 3 initiatives emanates from the southeastern portion of this watershed, Lake of the Woods. And the Grand Council Treaty 3, Anishinaabe Nations allied to create the Nibi Declaration. And the Nibi Declaration is based on principles of Anishinaabe law, lists them in a way that is very declaratory, non-prescriptive, and that's one key feature of how Anishinaabe law is structured. It's based on voluntary compliance. Okay, so the declaration applies to everyone in interaction with water everywhere. There are no direct consequences for breaches of these obligations, again, in accordance with structures of Anishinaabe law, but there's strong encouragement. So in relation to this initiative and this formation of a declaration, which was done in accordance with the lawmaking process of the Anishinaabe Nation, built on the 4 directions model, using the knowledge keepers, elders, the Women's Council leading this, done through ceremony and through National Assembly and a national forum. We end up with this Nibe Declaration that has attached to it a curriculum and voluntary compliance measures and initiatives built into the rollout of the declaration itself. There are water walks on a regular basis. People have signed on to the declaration from every possible part of the world, which is very interesting to see the support for this declaration. I think the key moment for me in terms of understanding the scope and reach of it was to hear about a young man in Winnipeg who drinks water from this watershed, saying to his mom, I want to put the declaration on my wall in my bedroom, and every night reads part of it and prays to the water, right? He's taken up that responsibility. He's recognized the value of this. And these are future decision makers and leaders in a variety of different contexts. So thinking about the reach and scope of the Nimby Declaration. So what does this mean in terms of governance? It's what some might consider soft governance, but that's actually had a pretty significant reach to date with school curriculum integration, international buy-in and voluntary compliance sign up. So that's one initiative that I think is worth mentioning in terms of the Lake Winnipeg Watershed, and thinking about how this is now translating to efforts and initiatives to engage the International Joint Commission in relation to transboundary water, because Lake of the Woods sits on the US boundary. So all of the water that's flowing into to the Lake of the Woods Basin is actually coming from the United States, and then is flowing through the Winnipeg River and into Lake Winnipeg. So right now, what Grand Council Treaty 3 is looking at is that relationship with the International Joint Commission, but also working on its transboundary relationships with the Anishinaabe tribes in the United States. So thinking of a transboundary alliance between those nations that build on some of their established mechanisms of communication and cooperation. So it's allowed for Grand Council to affect its own governance and decision-making, and the values and principles here are directly influencing its role also in the regulatory governance board for water levels within the lake. There's been a lot of public information uptake, knowledge building within the Treaty 3 nations as well, relating to this as a starting point of that affirmation of relationship. All right, second initiative. Imagine yourself in the waterscape and driving west and up the west side of Lake Winnipeg to Mississippi Cree Nation, also known as Grand Rapids, but there are no Grand Rapids there anymore. It's the site of a major hydroelectric development, the first in northern Manitoba in the 1960s. So the riverbed and the rapids are silenced. They're actually blocked off. Trees are growing in the middle of the riverbed. Sometimes water is released and washes away those trees, but you can see age-old boulders that sit and hold the place of that riverbed, that historic riverbed, which was an important gateway to Western Canada and the Saskatchewan River. There's a great deal of emotional, cultural trauma associated with the building of that dam for Mississippi Cree Nation. A lot of trauma also related to community impacts relating to the construction itself, but also the social impacts relating to having people displaced on both sides of the river and a significant hydro presence within the community. A lot of children born of the dam development, and a continued presence and significant amounts of reported racism between Manitoba Hydro and the community members. I won't get into that, but it's a very important part of the history of Mississippi Cree Nation. What we did through the Decolonizing Water Project with the community was to do a revitalization of their Cree laws. So to work with them, their elders, through story, but also just sharing with the intergenerational transmission of knowledge. So sharing between the elders and youth that were part of the community camp on how you achieve a good life. What are the governing principles? And then putting them into a structure that you see illustrated in these, the beautiful logo on the shirts of the council members in this photo. What that represents is actually a 5-petaled flower pattern. That's a historic beading pattern from the nation that speaks to their own particular form of constitutionalism and how certain pieces are attached to each of the principles, how they're distinct from each other but integrated, and that the vines and petals are about the legal principle and concept of Wakotoan, which is of being in relation and what ties things together. The reason you do things is those family relationships. How you do things is because of those family relationships. And that's what Elder Stella Neff is explaining here. We have two, I think, very well realized videos on the Decolonizing Water website that explain each of those legal principles. So that's part of the continuing legacy that this project is leaving for the community and their own governance initiatives. Understanding through a fluent language speaker what each of those values and principles holds for them. And also a video that speaks to the whole integration of the Cree Laws project and how each of those principles interrelates. But also thinking about how those are the principles that exist within jurisdictional authority that is territorial and jurisdictional authority that is subject matter based. So this Cree Laws project is not only being used in relation to water governance, but also to enhance the work of the Guardians program and the child welfare law that the nation is currently developing. A success story that comes from this initiative of this Paistic Nation is the regulation of their own fishery. So in the summer months, there's an important commercial fishery within the territory. In the winter, there's a lot of sports fishery. You won't be familiar with the legal landscape in Manitoba, but Métis harvesting rights allow Métis harvesters to come into Grand Rapids First Nations territory and take fish to feed families a significant amount of fish. And then there's the sports fishery. It was putting a lot of pressure on the fishery that is in proximity to the community. And the provincial regulations were not meeting the conservation goals of the First Nation. So they actually exercised their own jurisdiction and created catch limits that they then enforced. I say enforced because what they did was to ask people to voluntarily comply. They said, this is our regulation. This is the legal basis of how we assert this authority, why we assert it, why we've made this determination. We're not going to punish you or force you to comply in any way, but we're asking you to recognize this authority. So again, that non-interfering voluntary compliance approach was adopted here. Pretty significant success rate. There's always situations in which people are not going to want to voluntarily comply, but the reality is even if there was provincial legislation or regulation, they wouldn't be complying with that or potentially not complying with that. The Guardians have also stepped into moose management and forest management to share information, be apprised of what's happening within the territory. So there's relationships developed even with settler hunters within the territory to be reporting their moose kills and moose population location information to the Guardians program. So that mutual exchange of information has been part of that affirmation of jurisdiction through the Guardians program. So the last initiative that I was hoping to speak about is the Lake Winnipeg Watershed Treaty. This is an initiative that's in its earlier phases of development, so we don't have a fully fleshed out water treaty to share with you today. It's something that will take time. There is a model on which this is based, which is the Buffalo Treaty that was initiated by the Blackfoot and Blackfeet nations. The idea here emanates from long discussions around the lake and with the Lake Winnipeg Indigenous Collective and 14 nations that are Cree and Anishinaabe around Lake Winnipeg towards the recognition of rights of nature through legal personhood. The overwhelming response that was received by the nations is that that was not a good fit with how they viewed their sacred responsibilities to water, and that they preferred to think about how they could recognize the spiritedness and agency of water through some mechanism that would bring nations together. So co-jurisdictional, transboundary water governance through a water treaty. And we saw together that map of the Lake Winnipeg watershed. Again, the Blackfeet, and this is part of that inspiration, Blackfoot in Alberta will be involved with Saskatchewan Nations, Manitoba, and the Grand Council Treaty 3 and Anishinaabe Nations in southeastern Manitoba. I'm sorry, I'm gesturing to a map that works for me, but it's actually like this. Okay. So, those are a lot of different nations, different settler legal contexts to bring together into water governance. We're not sure what it's going to look like. Is it something like the Declaration with voluntary compliance? Is it something more along the lines of Cree laws and trying to create something like the Seal River Watershed Alliance, where they've worked with Dene and Cree nations on building a common legal framework? So those are things that are going to get worked out over time. And it's being led, as I said, through the Lake Winnipeg Indigenous Collective. Part of the movement forward is going to be confirmed through the annual Nibi gathering that takes place in the Whiteshell that brings nations together. This year, it's May 23rd to the 26th. Everyone's invited. I would highly recommend that you journey to Manitoba. It's at a place called Manituapi, which is the place where the Creator sat. I know that every nation has their own story of how the Creator sat within their own territories, but this is a very significant place of petroforms and of water confluence for us in Treaty 1 and Treaty 3 territory. So that gathering is, as I said, May 23rd to the 26th. And the intent of that gathering in itself, and this would be kind of the fourth illustration of alternative forms or Indigenous forms of water governance, is that this gathering takes place and has been taking place for over a decade on land in a traditional teaching lodge, an Anishinaabe Wigwam teaching lodge. Brings together people from all different nations, different spaces. We've had international Indigenous collaborators come into that space, reporting on activities and mutually supporting each other. So these forms of declaratory statements, sharing with each other, supporting each other are all built into how Indigenous law is given effect. So the implementation mechanisms are actually engaged through teaching and sharing. And the Nibi gathering is an example of that. So I think these are three and potentially a fourth example that can give you a sense of how within the Lake Winnipeg Watershed, Indigenous nations are taking up their jurisdiction and authority, doing it in different ways. The challenge remains, and I've come to this realization in working and thinking about what the role of the Canada Water Agency is going to be in coordinating freshwater management in Canada. That big question, that gap is, how do you get to a place and space of having those Indigenous laws and legal orders meaningfully affect water governance in Canada? And that space is uncomfortable because there's a desire on the part of, and we've seen this, on the part of judges, decision makers in provincial governments, and at a federal level, that desire to understand an Indigenous legal order and to apply it, but often with the wrong set of baggage or skills to be actually able to meaningfully engage and influence decisions through those legal orders. And so that I don't even like the language around this. And as I said, I'm thinking and I'm looking forward to the discussion that we're going to have about this. I don't think it's a translation. I think there's a mutual recognition piece that needs to take place, and that these initiatives will be and look different in a variety of different contexts, in these different waterscapes, and that there are going to be some growing pains until that jurisdictional authority and sovereignty is realized. So I think a lot of this is tied to like the manifestation of Indigenous sovereignty and self-determination, how there's continued discomfort with that on the part of those who claim Crown sovereignty and continue to uphold the legal and political structures that are attached to that Crown sovereignty. So there's an incompatibility and discomfort, but I think there are potential ways to agree to disagree and work within spaces of co-governance in ways that meaningfully engage Indigenous laws and legal orders in both the process and in the substance of those decisions. So I will leave it at that for now. I would be very interested in your thoughts on what the future of freshwater governance in Canada might look like. If you have other examples that you want to share with those who are present here, we are at that space, and it was clearly indicated by the Truth and Reconciliation Commission that we need to, in order to move towards reconciliation, deal with our land and water governance issues in Canada. This might offer some insight into how that will develop. So much more to be said, and I'm thinking, as I'm looking at you, I'm thinking of a variety of other things we could talk about, but I'd love to hear from you.
Thank you so much. Thanks for putting up with the weird echo that has been going on this entire time. Sorry about that. So we'll open it up to questions. Just a reminder, if you're in the room with a question, we'll ask you to come a little bit forward so that you're picked up on the mics for the benefit of the people who are with us online. If you're online, Kylie, who you can't see off screen, is monitoring the Q&A and will let us know when there are questions. And I think the simplest way to proceed is that you would ask the questions. Yeah, so Kylie will actually speak the questions that are in the Q&A. Immediate hands shooting up in the room or online?
I really don't want to hear anyone say, I know how to fix that problem. I just wasn't brave enough to come forward.
I'll ask a question then, because something you said just at the end really caught my curiosity. So you said one way forward is mutual recognition, and you started to say what that might entail, but I wasn't really clear who would be recognizing what. So can you say a little bit more about what you mean by that?
Yeah. So in a lot of the shared decision-making examples that we looked at where there's actual successful movement forward on achieving common goals, there's a recognition that there's a disagreement about jurisdictional authority. There's also, in large part, some kind of implicit agreement that the information or data, for lack of a better term, being used is going to be different in nature, that the process by which decisions are achieved, for example, consensus, and that the values and principles for that decision-making are going to be different. Process two, I think one of the things that came out very clearly from the interviews was that time is considered to be a luxury in a lot of administrative processes, but we're absolutely essential to like Indigenous realization of their governance objectives, and kind of placing pauses on some of the advancement or the quick pace of decision making had ultimately a positive outcome for both perceived from all sides, or all those who were involved. I shouldn't say sides, because in some cases what they're really trying to do is bring that consensus ethic into the decision making or recommendation process.
There is a question at the back. Please come on down, and there's two other questions. You are probably close enough for the mics. We'll start here. Yeah, you just come a little bit up to a bit close to the mic. There, you see it there? Yeah.
So I have a question around, I don't have that strong of a legal background, but in terms of the process, how you go about, in doing this, what steps, what structural steps or phases exist, from recognition or from, like you've explained, you look at the treaties and all that in terms of origins. But if you were to just formulate the steps for the process, I think it would be helpful for the non-legal audience just have the steps in the process in mind.
The three initiatives that I talked about, those cases.
Or in general, how going about.
Yeah, so those case studies are very much, thank you for your question. The case studies are very much generated from the community's own process and desire to move forward in a particular way. So if we think to the Nibé Declaration, I prepared a brief with every possible water declaration in the world that I could find, and then another with all of the different approaches that we might take. None of those approaches ended up being the approach that we used. We used a 4-directional model and also the process that the nation had established through the making of their Manituaki Nakunagewin, so their Great Earth Law. To actually understand that process, we had to go back to people who were involved in the 1990s and hear about how that decision-making had taken place, what the ceremonial steps were, how to involve the different parts of the nation, so 28 First Nations within the nation. One of the things that shocked and surprised me was a disagreement about the Anishinaabe terminology to use to refer to water. Never had I imagined that that would actually come up as an issue, but that became a central piece that required a significant amount of discussion and a whole secondary process to work through. So, the principles that I talked about, like the adaptability, the flexibility, those are inherent in each of those processes. Through the Cree Laws Project, originally we had anticipated that probably most of the values and principles would come from Wisaki Jack Stories, who's a central figure and character in Cree culture as a kind of a teacher of sorts. The elders that we assembled did not want to talk about those stories. They wanted to talk about the way of life before the dam. So for them, their point of good living, which is the center of that flower, is everything that's before the dam existed in the 1960s. So some of them had that as a direct reference, some through kind of third-party information, but almost directly. As they were elders, they were most likely around in the 60s. That was their point of reference, and that's how they decided to share their stories, which is very interesting. Not at all what we expected. I did come to them with a variety of Cree words, which with Anishinaabe in influx, they're the same language root, but they had a good laugh at my expense in terms of how I would pronounce Cree terms. And so we had a lot of fun around that. And they said, "Where did you get those?" I said, "Well, I assembled work from every Cree scholar I could think of, and I'm bringing them to you as a starting point for the conversation." To which they said, "That's really lovely. We don't want to, that's not what we're going to do." Right? So I think the same applies to how you would set up structures of co-governance and co-decision making, that it's going to be very responsive to the particular context. So is there an issue of governance that needs to be addressed? Is there a problem? Is there a particular area? Is there an endangered caribou herd? Whatever that might be, and responding directly to that, taking into account Indigenous governance principles. Right now with the Seal River Watershed Initiative, I'm very excited about what they're doing, what they're accomplishing. Being able to withdraw an entire area that has significant mineral resources, to withdraw it completely, and to be going through this feasibility study for an Indigenous protected area is very exciting. The foundational work that they did as 4 allied communities to create to Dene to come up with their declaratory principles that are rooted in their legal systems was very powerful work. So, I think that holds a lot of promise, probably the one that I've seen that has the most promise kind of in that northern part of Manitoba and within our territory.
I'm actually going to move the mic toward you.
Oh, thanks.
That'll make it even better. Can you just reach it to you there?
I think so.
There. And then get it back after.
Okay. Hi, thank you. I was wondering if you could speak a little bit more to your experience in the kind of process and choices and value in sharing Indigenous laws and Indigenous legal orders beyond the communities or the nations themselves, because I know many nations, at least with whom I work with, are in the process of revitalizing their own legal orders. But that decision to share it with whom and how is, I think, sometimes a really difficult question. And you spoke a bit to how the NIBI Declaration has brought nations together across Canada and globally, which is really interesting. But I'm thinking even more so in terms of like Manitoba Hydro or BC Hydro and these kind of settler authorities or decision-making bodies, and like that process of like sharing legal orders in those spaces. I just want to hear more about that, please.
It's a very good question. I don't have an answer to it, but I have thoughts about what are some of the missteps. One is, I think, providing a fulsome package that would lead anyone to think that they have full understanding. The elders that I work with in Treaty 3 say over and over again, Anishinaabe law would be like an entire library, an encyclopedic library that you could never read from front to back, and your evolution in thinking is constant. And that's part of the methodology of teaching and understanding Anishinaabe law, often through story, right? With no direct analysis provided to you, you're responsible for the analytical exercise and work attached to that. It's going to be different in each context, and with the nations that you saw in those examples, they're making deliberate decisions about how much and how to share, and also looking at tools that allow for public dissemination. So there's a curriculum, a NIBE curriculum, and they thought that was incredibly important and it's internal to the nation, but also usable externally. So they wanted to do that, and signage at the entrance of their territories, the declaration at every boat launch, and met with lodge owners to share some of that. Often I get asked, go share this information, and there's a variety of different ways of sharing that in those different contexts. There's a lot that's also reserved internally to the community. And I think of a different example where we've done a wealth of oral history interviews. I don't like that terminology, but interviews with knowledge holders, and those are reserved to the community. And there's been no further process. And that's just a choice. I know that when I did my graduate work, I did interviews, and I was, as part of my consent, I had ongoing consent and withdrawal at any point in time. And the question that I got from the ethics committee is how, this is part of your work. If you have no consent to use this, how are you going to, if someone withdraws consent, how are you actually going to continue in your work? So that's a risk I'm prepared to take. And it's kind of the risk with the rest of this work as well. It's not about, the research outcomes or deliverables. It's about creating things that have meaningful impact within the community, and that are done in ways that are deliberately decided upon within the community in accordance with their own structures. So Treaty 3 was adamant that this should be done in accordance with the Anishinaabe legal process that they had used for Manitoaki and Okanagan, which had a significant amount of ceremony built into it. And those parts are not reported on in any way. Any further decision-making about what to do with that would go through the same process. Something that's being engaged right now, but that's not something that's publicly shared. And I would say the same is true for every system of law. In terms of what we know about the legislative process, there's a lot that we don't know about how legislation is made, the whys, the policy behind it, and this is in a very supposedly democratic and open legal system. So as I said, I question also kind of what needs to be put forward in what spaces. And ultimately there may be some times where, or a point in time where there will be different views on it. If I think of work with elders 25 years ago, recording was not permitted. I remember even wanting to write things down with a pencil and paper just for myself because I think better, and being told that was not appropriate, to now being invited into spaces and asked to record, asked to publicly share and make those resources available. So there's, I think, the attention also that will arise in communities and is being dealt with in different ways, relating to kind of what is individual and what is collective, which is a big challenge. But those are important discussions that are ongoing. Good, very good question.
Jocelyn, you have a question?
Yes,
right?
yeah.
And we want to. Oh, there's 3 online.
Great. Hi, Amy. I'm Jocelyn Stacey, white settler legal scholar, law professor here. This was fantastic. I took so many notes. I've got lots of questions. I'm going to ask one and then hopefully we can find a minute to chat. So I'm excited to read those 2 governance reports, which I'll do closely. So one of the things I'd like to hear your thoughts on, because I really appreciated the distinction that you drew between governance and management, and the way in which, even with some of the successes that you document in the reports, that there are all of these ways in which the Crown still kind of holds the jurisdictional cards at the end of the day. And so sometimes in law, we often think about settlement or negotiation happens in the shadow of the law. So I'm sort of curious about your thoughts on the relationship between what you're seeing in terms of these governance relationships and then Canadian constitutional law. And how much is this about, at the end of the day, the way in which the framework under Section 35 has been articulated does not recognize Indigenous jurisdiction? And do we need that piece to change before we can see more meaningful shifts on the ground? Or is it the other way around? Or how do these 2 pieces of these approaches that you're seeing taken on the ground interact with, the sorry state of Canadian constitutional law?
I think part of the challenge that makes things feel insurmountable in many of these contexts is the zero sum of jurisdictional authority, that it rests solely in one place or the other. And that's, there are nations that take very strong positions in relation to sole jurisdiction and authority, and others that have ethics of potential mutual recognition or agreements to disagree. I think that there's a whole spectrum. This is something that I want to explore further. So I wouldn't claim any expertise in this area or kind of having an answer, but where I think there's potential is in thinking about shared decision-making that recognizes mutual decision-making authority, so that you're not stuck in the zero-sum conundrum. How that practically will work out, I think there's a variety of different ways to reach that. And whether or not it's going to be ultimately successful, I don't know. But I think it is a very critical question as part of this conversation. Do you have some thoughts?
I mean, I do. Yeah, maybe we should chat afterwards. Yeah. That's really interesting. I mean, I'm stuck in a zero-sum game in some way, so that's really thought-provoking. Yeah.
I work with Denny in Northern Manitoba, who are involved in the Seal River Watershed Initiative. They have been in recognition mechanisms and negotiations for a very long time. So they've had negotiations north of 60. They saw the Nunavut land claims agreement be concluded in part of their Denny territory, their transboundary interests, right? So I guess the enhanced version of response to that would be creating spaces of or abilities to resolve through conflicts of laws, or looking to interjurisdictional mechanisms related to particular issues or territories. And I think that's part of what I've recommended to the Canada Water Agency, and part of how we're structuring Decolonizing Water 2.0, because we have a grant application in for continuing the work of decolonizing water, is, what are the ways in which we can create these structures of mutual recognition of of authority and collective decision-making. Of course, in Decolonizing Water 2.0, we want to do that led by Indigenous people and principles and values at the forefront. But yeah, I think that those might be two potential ways of thinking about that.
Pass back over for me. Thank you. Okay, so this is a question from Nicole saying, thank you for your thoughts and sharing here. I heard you talking about examples of a successful voluntary compliance, and I wondered if you could speak further about how on the ground nations are achieving this voluntary compliance, especially with non-Indigenous fishers or stakeholders, because there's, of course, great potential here for conflict and anger-driven responses to Indigenous nations asserting their jurisdiction.
Mm-hmm. I would say from the Miss Pystick example, I've learned a lot from them about how to achieve that. One of the ways they do that is through education. So they are very engaged in providing education about their values and principles, about their conservation initiatives, about their relationship with moose. So that's a key part of how they exercise their guardian's function. I think education also to them and training about conflict resolution and, stepping aside. So that voluntary compliance in their context necessitates that if there's a potential for conflict, that they're trained to withdraw from it and to leave those things. There's a concept in the Cree laws framework that is Ochinewin in Anishinaabe, and one of the words they laughed at me about a lot. But essentially it's about kind of karma resulting from your actions. And so that's an important part of how their guardians are trained, is to say, we don't necessarily need to step into the space. We'll take these actions and fulfill our responsibilities. But then what's done with that is not really ours to carry. It will belong to that person or their family, or they'll have to deal with the consequences of their own actions. It's not up to me. They're not into enforcing in that way. So I think that's, a very good example of how we might think about avoiding conflict in those spaces. I really like what they've done. They also have junior guardians that are like some of the neatest people I've ever met. They're so cool. And they're getting to know their land, and Seal River Watershed, same. They're on land and water. And they have actually in Seal River rescued some people, canoeists this summer that were, or I think actually they were mineral exploration. They were doing mineral exploration in the territory. They needed to be rescued. And it's like the junior rangers and Seal River Guardians, the people that know the land, that know how to deal with the unique circumstances of that territory, that had to rescue them.
So if I can just jump in, we have at most 5 minutes left, which is, it's great to see that there's still hands. Can I just suggest, Kylie, why don't you read out those other 2 questions and just sort of leave them out there? If you have immediate reactions, go ahead. But I would thought, why don't we take the 4 remaining questions and then see if you have any final thoughts. So it'll be the 2 from Kylie online, 1 from this gentleman here, and 1 from the person in the purple or violet or whatever that beautiful color is.
Okay, so our remaining questions from online include a question about, in the BC context, there are many small nations, and capacity to engage and collaborate is often an issue we face. Any thoughts on how to make things easier to collaborate and approach nations where they are? And then the other question was in reference to your answer to your first question, saying that you mentioned that a key part of mutual recognition is the implicit agreement that the information or data is going to be different. And if you could expand on that and describe an example where this aspect of mutual recognition has been done successfully, or what it would look like.
I think that Mike will catch you from there.
Yeah, okay, perfect. I think I found it very interesting that how you were talking about how Indigenous law is kind of voluntary law, if I understood you correctly. But I'm wondering how impactful that is. In the report, it's it states Indigenous groups have the right to be consulted, and that's a very common, but it's not really meaningful in that way. And so I would just wonder how like voluntarily laws would apply in the same way. Like the way I was thinking about it was kind of like Indigenous law, kind of like when somebody comes over to my house, I have like these rules, but they're not really like laws, they're like voluntary rules for you to come into my house, like take off your shoes and stuff like that. So I was just wondering like how entrenched or how important is voluntary law, or is this just another like consultation, but without any teeth?
Okay, good question. I want to tackle that.
Can we just take the final one? Or do you want to tackle it right now? Okay, no,
Really
we tackle it right now.
So I don't want to lead to any misunderstanding that all Indigenous laws and legal orders are about voluntary compliance, like very much in the Anishinaabe context, to a certain extent within the Cree context. I'm not going to speak to any other nations. They may have strong rules and regulations. Some have actually ventured into making their own laws and regulations that resemble very much settler law and that have consequences attached to them. So it's not to say that, not to paint everything with the same brush, certainly. And also, I think we need to distinguish between the Indigenous laws and legal orders emanating from nations versus kind of a state law response or rights that exist for Indigenous nations within the Canadian constitutional construct and in international law. So there are rights and obligations and, absolute requirements, for example, constitutional duties that relate to Indigenous peoples in their own laws and legal orders. And in Anishinaabe law in particular, there's this ethic of voluntary compliance. And that's just about how that legal system is structured, right? It's not going to be the same. And I know that some nations have very like more warrior societies. When we often say, like on the prairies, it's very conciliatory. And if you look at that in the context of treaty making, the idea that we made agreements, we shook hands to share, illustrates kind of the backing of that Indigenous legal order in that context. So definitely don't want to paint everything with the same brush. And to the questions of, smaller nations, how to engage, I think, small can be very powerful. If you look at the Seal River Watershed Alliance, some of the Dene nations, they're very, very small communities, but with very strong leadership and still very fluent in their languages. So I don't think that the power necessarily results from the size. I think, where you are, I would say politically, geographically, all of those things will influence also just the nature of the leadership and the visionary conversations that are happening with communities and what has been the history of colonial impact within those different contexts, right? There's a wide range of possibilities of response within those within the nations in Canada.
Can you make your question really brief?
Thank you so much. So my name is Hal. I work in the Mekong River context, and I'm very interested or curious about your thoughts on growing the kind of alliance, because I see in many cases there's some willingness or leadership, but sometimes there's lack of funding. Sometimes the availability of funding is a problem. And what are the conditions of the processes that are needed, or from your experience, to really help make these alliances or collaborations related to online question better or more possible?
One example that comes to mind is actually what's going on with the Magpie River. And when we think about mutual recognition, that would be one of the examples that we probably should talk about. The municipality and the First Nation have issued sister declarations that are identical to each other, stemming from different places of authority, recognizing each other as legitimate authorities and issuing these two different legal instruments, but that are mirrors of each other and supporting each other in advancing their common interest in protecting the Magpie River. So I think that's
different, even the value of the water, it just seems then impossible to even.
Yeah, and I think that they have, the municipality, which is a corporation and a structure, is going to see things differently than the Inuit Quanishit, but they've agreed on that one objective, right? And a mechanism and a means to get there. To ask for full and complete synchronicity, I think might be too much, or it might not. Those are those are political determinations that are made by nations that are engaging in this type of work, right? I'm sure some people are critical of the Magpie example and think that there shouldn't, that a municipal authority should not be recognized by the First Nation. That's a decision that they made as a nation to work in alliance and to do that work together. So.
Okay, so everybody, we have to call it a day there. Please help yourself to a bit more food on your way out and join me in thanking Professor Craft.